Okay, let's try this again. And I guess I'm out of it one more time. Okay, there we go. This thing's going to give me a hard time regardless tonight. And I apologize. I probably end up recording this thing on a Zoom and just uploading it until I can get this thing fixed. But I might be okay right about now. So let me bring everybody else back in, see if everybody in the chat room is there. If not, it's all good in the hood as it should. There we go. Let me see where I am on my YouTube page. I know I'm live somewhere because it's showing it to me. So I'm going to get back on this case because I think it's important to give people an overview that hopefully benefits them in their current situation. Make sure I turn off this background in case it pops up and I don't want to hear myself any more than I have to. So let's do this YouTube thing. See where I'm playing. I'll stick it inside. I'll fix it like we did last time, and we'll get back to work on it. So I'm back up. Everybody know I'm back, and they can always show this to whomever they want to. I really don't care. Let's go here. Let's see what we got going on live. Go to my page and try to look at my channel. Oh, it's actually showing me live, so I think we're good to go. So, oh, there we go. Let's go to work, people. So, that being said, I'm going to go back to where I was originally. I guess everybody might have gone to sleep. It's all good. I apologize when I'm back. Sorry for the delay and the mishaps. So now what it appears that I probably need to be doing is simply going live, and I don't know if I should schedule it or not, or maybe schedule it through here. I gotta get this stupid thing figured out. But at any rate, I'm gonna go over here because I want to get this done anyway, because I'm kind of tired of hearing about some of this foolishness regarding some of these cases. I don't know why it gave it to me here. I'm not sharing my screen yet, thank God, because you all can't see what I just did. But I'm gonna go in here, cut down this, find my Holmgren case, a Holmberg. I don't know why I keep calling it Holm. I think I'm thinking of Mike Holmberg, Holmgren, I guess, of he used to coach the Seahawks and the Packers. But at any rate, I'm here on the case, and what I'm gonna read for everybody involved is I'm gonna pick up where I was before. and if you're not there, it's all fine because you're going to get the video. We'll go over it and we'll be all on the same accord from moving forward. So let me share the screen from window. Let's do this. Share it. And I think we're doing a good job now. Here we go. Everybody should see this. And hopefully video's there. You see if you hear my voice. I hope you don't need this in order to hear my voice. That would be pretty bad. And since I'm the only one in here, I don't know if I take my picture out if people can hear me, but I'll leave it in here just for the sake of argument. And because I'm such a small, the picture is such a small one, we'll be able to do what we need to do. So I'll maximize this for everybody. And let's get the full screen here. And I want to get this chat overlay, not really out of the way, but let's see if I can. move this thing over while I'm reading it. I don't think so. It's only going up and down, which is not good for any of us who are trying to get this information. So let's get this chat. Okay, there we go. So back to where I'll just start from the top. And again, I apologize for taking us this long. But anyway, the instant case is a consolidation of 3 appeals. Those who don't see this, right there, the consolidation of 3 appeals to the Court of Appeals challenging the constitutionality of Minnesota's administrative child support process. That's what this case was about. So that's what the case that the court was listening to at the time. That's it. They wanted to know whatever the questions were. You'll find out that the district court sent this case up to the Minnesota Supreme Court. Go here. This appeal presents the issue whether the administrative process, and I'm going to change the color on this, and here's what it wants to know. It presents the issue of whether the administrative process violates the separation of powers doctrine by impinging upon the original jurisdiction of the district court. Right there. You see that, people? The issue, the administrative process violated the separation of powers doctrine by where it says impinging upon the original jurisdiction of the district court. You see that clearly, and this is the case that came out of Minnesota that so many people seem to swear by, says that child support is unconstitutional. I just said, listen, let me just try to help people out. I'm not a guru. I think I read pretty well. And despite some people thinking I may have a little bit of a condescending tone, it's not my intention. But when you do this stuff a lot, and by the way, I did spend some time working with a law firm, you kind of learn things from several perspectives. But the biggest thing people tell you is to learn to find out what was the issue before the court. So the issue before the Court of Appeals is whether the Constitution, the administrative process, and this is back in 1996, so I think the case came out in 99, as well as I think there was a stay in this case as well. We'll get back to reading it. I'm in Florida, didn't really care very much about Minnesota, but since everybody kept trying to swear to me that child support was unconstitutional, I just felt the need to address it and let everybody know that if child support was unconstitutional, there would be no more child support cases, at least not in Minnesota or anywhere where the Supreme Court of state ruled it unconstitutional. And of course, if the United States Supreme Court ruled child support unconstitutional, there would be no more child support cases in the United States because they would be deemed unconstitutional. Now, question here was whether it violated by impinging upon the original jurisdiction of the district court. I would suggest everybody go read this statute of Minnesota, and by creating a tribunal which is not inferior to the district court. So that's another question. So it's actually addressing more than one issue. Don't get on me about my colors. I'm just trying to separate it. That's another question that it addressed that day. And one more question that it addressed is, and by permitting child support officers to engage in the practice of law. So you see the 3. Furthermore, the Court of Appeal, the administrative process unconstitutional. So there you go. Clear as day. I'll put it in red. And if anybody wants a copy of this when we're finished, just let me know and I'll send it to you. So the appeals ruled the administrative process unconstitutional, and they relied on the separation of powers doctrine. You see that, people? It's clear they relied on the separation of powers doctrine. And what did the Supreme Court do? They affirmed the Court of Appeals, meaning they agreed with and hold, and this is very important. You asked what was the question before the court and what was the holding. The court held the administrative process is unconstitutional because it violates the separation of powers. Now, that's the opinion of the court. We can get into how the court came to their conclusion by simply going in and say, okay, what was the court talking about? And by the way, I think I need to highlight this affirming part for anybody who may be confused. We affirm. You see that? That means that the Supreme Court of Minnesota agreed with the Court of Appeals of Minnesota. And by the way, if you have any questions, I believe you can type it into the YouTube link, as well as if you're on my whatever this thing is, this Restream. And I'm actually using a different computer because I don't know what's going on with my main PC. I probably need to just shut it down and let it come back up. But nonetheless, once you finish doing that, you go into the court and you go into the rest of it, and you get down to where it gets into analysis and what have you. Well, let's go back up here and do a little bit of research because there's a couple of interesting points that I know are in here. As the court is holding in this case, timely distribution of family financial resources is needed to protect the children's well-being. So thus, the efficient administration of child support cases is a laudable goal and one that all three branches of government share. To this end, the legislature has created an expedited process to adjudicate child support cases involving families receiving certain types of financial assistance. You might want to go back this out because there's been some change, some subtle change in how they deal with it. But at any rate, while evidence of the administrative child support processes efficiency, efficacy, I should say, is hotly disputed by the parties, there is no controversy about the importance of streamlining child support mechanisms. You see that? And this is what, and I'm putting it in red because essentially the red part is what the court said, not of any religious context for those who read the Bible and know that the red letters are allegedly the words of Jesus or the Messiah or the Christ, whoever you may want to call him. Not trying to have a discussion today. But anyway, nonetheless, the importance of this shared goal cannot ignore separation of power constraints. So I don't know if it's necessary for me to go further. And what's going on? Appreciate you stopping by. And I apologize for the delay. I had some of my Restream on my PC, but I thought it was important because I wanted to get to this case, and I also wanted to get into the Blessings versus Freeston case. If there's anybody out there that has any other case or other issues, and again, I'm not an attorney. I do not have a license to practice law. I do not practice law. What I do is study law, tell people what I've learned and how I've gathered the information. I don't give this information as advice to apply to your specific case, but it's general information regarding the law and lawful principles, which, by the way, do belong to the people. I hope that you use this information for educational edification only. And the reason that I say that is because I want nothing that I say on any of these videos or even in any personal consultation to be construed to be legal advice. If you feel you need legal advice, I would highly encourage you to hire a licensed and hopefully competent attorney in your state and be legally advised. With that being said, if you wish to continue to follow this narrative, you may. And again, I hope you can gain something from this. I'm going to do another video. I may even do a follow-up because my other one is giving me a headache, of how to go through my Dropbox to see the many cases that I've had, my wins, as well as the number of ass kickings I took up into the point where I started to see some sort of success. And what I do is I show everybody my docket. You can go into the Dropbox. It's on it's actually inside my bio, I think, on the YouTube intro page. You can go in, you can hear audio of me inside of courtrooms. I know you saw me inside of these hearings, but there's also audio for me inside of courtrooms. You can actually watch me on this YouTube channel. I've had 3 appeals in front of the District Court of Appeals. The first one about child support is interesting because you can't hear my voice, which doesn't make any sense. So anything that you want from me that I can share with you, that you can utilize to help people out, that's what I'm here to do. I don't want anybody to go through what I've gone through or what I went through before I started getting the successes that I've had. And I tell everybody this: If somebody has done something, they can show you what they've done, and it doesn't tell you how they did it. Michael Jackson can dunk. I mean, not Michael Jackson. Michael Jordan. Michael Jackson, blessed dead. Sorry for using him. But Michael Jordan could dunk a basketball. He can say, "Hey, listen, I go to the rim, I jump, and I dunk the basketball." You see him doing it. It doesn't mean you can do it unless you have either that skill set or you put in the necessary work to get over the hump of being able to clear the rim and dunk the basketball. And even with that being said, your jump shot may still suck, and that's something else you need to work on. You may not be able to be Mike, but you can still be a successful basketball player. Ask Steph Curry. That being said, the current child support process is an outgrowth of Minnesota's response to legislation enacted by Congress. I probably should do this right here. It's their response to legislation enacted. The courts don't make law typically. If they do, it's called common law. But if there's a statute, and everybody wants to get into this Chevron case, when there's a statute that gives a clear explanation as to what the law is, that's what the courts follow. In the event the statutes are ambiguous or vague, the court may say, we're going to decide this issue and come up with a case law that's called common law. Statutes, codes, the courts following that stuff, that's law too. The courts are not supposed to deviate and overrule what's well-established statute. If you say what happened with the, what's this thing that was abortion issue, abortion has not been codified, meaning if the United States Congress or Senate drafts a law, puts it on paper, it's agreed to by a majority of the Senate, going over to the House, gets it considered and accepted by a majority of the House. It then goes to the president. He or she can sign that, and at that point, it becomes law. Go watch I'm Just a Bill. There you go. When modifying public assistance laws in 1984, Congress mandated that states create expedite. Now they're talking about the federal courts. Congress mandated that states create expedited administrative and judicial procedures for procuring, modifying, and enforcing child support over people receiving public assistance or seeking government help in enforcement of the order. And by the way, you look down there a little bit further down, what do you see here? You see that, people? And again, I'm trying to be as well, and I get yelled at sometimes, and they're good guys. The attorneys that I've done some independent paralegal work for, but these are the things that I think sometimes so many of us as self-represented litigants fail in, is you have to kind of say, I want to step outside myself and just read the law or read the case for what's there. Sometimes you may want to look behind the black letter laws, they call it, to try to find a strategy for addressing what your issue may be. That's what I can apply for as a helpful. That's what I do. I say I'll read the law for what's there. I don't have any expectation one way or the other. Read it for what's there. But the interesting thing is when you read the law or read the cases, it gives you some strategies for your offense as well as some strategies for your defense. And hopefully that makes sense to anyone out there. So there you go. So let's go back further and get into some of the meat of why Minnesota was addressing this issue. They tell you some more history. In 1988, Minnesota began an administrative hearing pilot program in Dakota County. That's Dakota County, Minnesota. Under that program, the administrative law judges, which they had to address what made it unconstitutional for the law judges to be in law, presided over hearings related to child support issues when the county human services department either was a party or represented a party to the action. So here you go. They had the administrative law judges presided over hearings in which the issues involving Dakota County were a party or represented a party to the action. What's interesting is I think they're telling these law judges were out of Minnesota, out of Dakota County, which would give a conflict. But anyway, well, administrative law judges, and by the way, you see how they do the ALJS, and once they tell you, and after that they abbreviate it to let you know that that's what administrative law judge means. But anyway, while administrative law judges were empowered to make findings of fact, conclusions of law, and recommendations, only the chief administrative law judge or his designee could render final decisions and orders. Right there. And that's kind of crazy in and of itself. But right there. Only this guy could make a final order. Now, what's interesting is final orders were treated like agency decisions. And by the way, how do you appeal it? Appealable to the Court of Appeals and by way of writ of certiorari, and were enforceable by the contempt powers of the county or district courts. So you would want, if you're in Minnesota, because if you're in another state, you might want to go to your state's constitution and find out how your state's constitution lays out how you appeal an administrative issue, because some states can operate administratively, some states are judicial states. Florida is a judicial state, a judicial state, and although Florida does have an administrative process, it's subject to judicial review. And for those who don't believe me, go to Article 5 of the Florida Constitution. It's clearly outlined. Okay, and knowing how to appeal and how to properly appeal is very, very important as you move through this through your journey. Now, the statute, here you go. The statutes enabling language also authorize non-attorney Dakota County employees acting under the supervision of the county attorney to prepare, sign, serve, and file motions for obtaining, modifying, or enforcing child and medical support orders and maintenance and related documents. And you can go down there and you can see where Minnesota statute covered it, and the case law that refers back to it is a case that we've already seen somewhere in this document. At any rate, these employees, called child support officers, you see this clear as day, called child support officers, could also appear at pre-hearing conferences and participate in proceedings before ALJ, which is administrative law judges. This sounds like a mess at one time. And for the next few, that's crazy. Anyway, but for the next few years, the administrative hearing process underwent annual modification expansion, and it probably is still going through that. And if you look at any of the new cases, you'll probably have a better idea as to what was really going on. By the way, in 1989, which is another as 88, based on both on the success of the Dakota County's pilot program and the withdrawal of exemptions from 16 counties by the federal government, the legislature expanded the reach of administrative hearings. So now you're getting some history of it, but you also should understand that even with this being the history, it's not unconstitutional. What was unconstitutional was a violation of the separation of powers, which would mean that you still have to go back and address your underlying order, and that the order was procured by violation of the process. If in fact that's still the case with Minnesota law today, I'm not going to shepherdize it because I don't care that much. If you're in Minnesota, you can, or if you're in a state where this may sound similar, maybe you might want to go shepherdize law and find out where you are. Nevertheless, the Commissioner of Human Services was authorized to designate counties to implement the administrative program, and administrative law judges were empowered to hear here's something else that caught my attention before. Let me grab this one right here. We're empowered to hear uncontested parentage cases and issue final decisions without review of the chief judge. Meaning, if you all agree to it, hey, Saki wo, keep it moving. Now, in 1990, the administrative law judges' orders became appealable to the Court of Appeals in the same manner as district court decisions rather than by writ of certiorari. So what you would have had to know is, how did the district courts go about actually doing appeals? And by the way, you see they go to 6, go down to 6, which is 518.551, and see what the rule was then. But because we're in 2024, you may want to catch up to see what the rules in 2024 and how this situation is handled. And hopefully, sense to anybody who may still be on and listening. 1995, as you see, this thing is beginning to climb. The legislature required all counties to create administrative child support processes to resolve child support matters involving the public authority. And matters are tracked as either contested or unconsidered contested proceedings. You see that? Now, in an uncontested proceeding, which either party can elect, in an uncontested proceedings, which either party can elect to bypass, parties are given 30 days to respond to the public authority's written notice requesting information to prepare a child support order. So you see that in an uncontested issue. The public authority then prepares proposed orders for the party's signatures and the administrative law judge's ratification. If either party contests the order, they moved into the contest hearing process, which probably sounds like it's going to be something different. And since it's an 8, this is where you could have found what that process was and how to handle it. The contested hearing process is similar to the pilot program described. County support officers draw meetings and prepare hearings without the oversight of a county attorney. While is it child support officers? Yeah, is it county child support officers? Where was it? Yeah, let me show y'all something so I ain't got to go through this right here the first time. Oh, child support officers. Control F, by the way. Hit Control F, and you can always go find anything in a PDF document or a Word document. That way you ain't got to keep scanning back up. So it's child support officers, right? So at any rate, these child support officers draw up pleadings and appear at hearings without the oversight of a county attorney, which is absolutely insane. While these people may seek out county attorneys, the statute bars county attorneys from playing an active role in review of information. Oh, interesting. Check this out. While these people may seek out attorneys with questions, the statute, meaning the law, was written and it barred county attorneys from playing an active role in the review of information, the preparation of default and consent orders, the contested hearings, unless the non-attorney employee of the public authority requests the appearance of the county. So that must mean there must have been some sort of process, which is absolutely crazy. So essentially, when it first started, people were just seemed to be running wild, throwing things on people. But anyway, I think without going over it, too much and becoming somewhat an overkill, I believe anybody can read it. The biggest part of this case is going and getting the holding, but I think in the administrative hearings, the administrative law judges have all the powers, duties, and responsibilities conferred on judges of the district to obtain and enforce child support and medical support in these cases. It's kind of like this theory is just how the court got to its decision. Nevertheless, I want to get through this because I just don't think any question as to what the issue was, that the administrative process that was used to acquire the order. And by the way, if I go through the whole thing, I don't think I'm benefiting people, but I believe what I've done is allowed you to see how to kind of go about reading a case, following the case, and seeing how the court came to its decision. And what they were doing is giving you what's called some background as you go further, because you see closely aligned with our separation of powers concerns is our discomfort with the role and powers of child support officers in the administrative process. And this came from the court, by the way. That came from the courts. The court is talking about while they went through all this right here. You know, it's not only is there a separation of powers issue, you're kind of given some sort of quasi uh, officer of the court powers to people who may just be some random uh, introductory or entry level employees, which that in and of itself could be granting them power that constitutionally or otherwise they don't have. So at any rate, I hope that at least me starting this, and I'll say this somewhere in a resource of people as a I'll call this with highlights. And now replace the one that I have. And with that being said, I'll come back in here and I'll pull up the Holmberg case. So uh, I'm hoping that what we just went over helps some of you guys out, and ladies as well. You know, I'm not don't really care, and it can get you closer to a more definite understanding as to what the law actually says. And I don't think anybody now would question that the Minnesota rule did not determine that child support was unconstitutional. What it determined quite clearly, and you know, you can go back when you go back in and look at it when you watch this video again. It was pretty clear. It just the administrative process violated the separation of powers. Did not mean that somebody could not file an action seeking child support, do it judicially, which would not be administrative at all, and the court could make the determination that based upon the facts of the case, one party or the other is after custody or whatever else is going on, may owe some economic obligation to the other party. I don't want to get into um, what attacks or what defenses one might raise related to um, the child support case itself, because there's any number of facts that would lead that you'd have to go through to determine how the court came to that decision. But again, it was pretty clear in this case um, that the Court of Appeals ruled the administrative process unconstitutional, and that the Supreme Court of Minnesota agreed with that decision. So I don't see anybody with any questions in there. I'm going to get into a quick summary of Blessings versus Freeston, and for no other reason that I just don't understand how anybody, and I do mean anybody, came up with the idea or the notion, only if you will, of course, that somehow Blessings versus Freestone said that child support was unconstitutional. I've never understood how people arrived at that, especially when you could just read the case for what it is. You see my Blessings case is in here. Oh, crap. Let me see if I can look on here. And again, bear with me. And by the way, if anybody has any thoughts, questions, or whatever, not only can you email me here, but you can always go to my Dropbox, which is inside of my YouTube page description, and you can get it from there. And by the way, I do appreciate the people who have watched the videos from me inside of my hearings. And let me say this also: both of my hearings involved judicial orders. So my process, although I was in an administrative hearing, it didn't really matter. My order was judicial, and hence there were some issues with process and things that the court could not overlook anyway. So that being the case, um, my situation is a little bit different, and I don't want to have anybody or conflate any set of issues in mind with what other people may have with their issues. And again, I think that many people can get pretty good outcomes, I think, if they focus more on how to address the order. You're fighting the order. You're being held to the order. So how Title 4D works, how the federal government does X, and the federal government gives Y the money, and the what is it? They tell you the what do you call them people? The hearing officers have some sort of relationship, fiduciary responsibility to the court. All that stuff it may sound good out here in this, in the ether, so to speak. It's all BS. At the end of the day, either the order is valid or it's not. Maybe you might want to attack some discrepancy in how they got the order. All that other stuff, it just sounds good for barbershop or beauty shop talk. It doesn't really amount to any damn thing. And that's probably why a lot of people don't get any positive results. And I'll show you what results are supposed to look like when I do my breakdown on my Dropbox. So let me find my blessings case somewhere here. I know I had to have a blessings case. And what blessings, well, we'll just read it together. Blessing essentially outlined or explained. I already started highlighting it for you all. In part of the dead space. Let's go to work, people. It says with highlights. I don't see any highlights in here. Let me see. Okay, yeah, there it is. So let me go back to my page, my page share. And let's see how I do this. I think I might have. How did I do this right here? How did I manage to make this thing? That wasn't what I wanted to do. I'm trying to find me a way to share my screen, but to share my screen, I had to first. Greg, you're tripping, bro. Let me try this. There we go. So let's go back and share my screen again. And here we go. The case that so many people talk about so often. I don't know why I did that for. So let's try this again. You give it to me, we can come back and get it again. Window, share. There we go. And everybody should be able to see it. So let's go here. See it? 5 Arizona mothers whose children are eligible for state support services under Title 40 of the Social Security Act filed this 1983 suit. And by the way, there was a federal action that they filed saying that they thought that they had a federal right to have the state enforce child support. I'm going to break that down for you. Respondents, 5 Arizona mothers whose children are eligible for state child support services under Title 40 of the Social Security Act. What did they do? They filed a petitioner. And who is the petitioner? The director of the state child support agency, claiming, among other things, that they applied for child support services. I'm going to change the color on this. They're claiming that they filed for child support services, properly applied for child services, and that despite their good faith efforts to cooperate, the agency never took adequate steps to obtain child support payments for them, and that these omissions were largely attributable to staff shortages and other structural defects in this program, and that these systemic failures violated, here you go, this is the one that made them crazy, and that these systemic failures violated their individual rights under Title 4D to have all mandated services delivered in substantial compliance with the title and its implementing regulation. They requested broad relief, including a declaratory judgment. This is what they wanted that they could not get in a federal court. They requested broad relief, including a declaratory judgment, not even monetary, that the Arizona program violates Title 4D's provisions, creating rights in them that are enforceable under 1983. That's color of law and substantial civil rights violation. What else did they seek? Crazy enough, they wanted an injunction requiring the director to achieve substantial compliance with Title 4D throughout all program operations. The district court granted summary judgment for the petitioner, which was the women, but the Ninth Circuit reversed without distinguishing among the numerous provisions of the complex Title 4D program, meaning the courts didn't even get into that, or the many rights those provisions might have created. They're not going to address what rights they created. The latter court held that respondents had a individual, here you go, the latter court meaning the Ninth Circuit, by the way. I want y'all to look at the Ninth Circuit and understand how your courts of appeal work. The district court said, yeah, the Ninth Circuit reversed, and without distinguishing among the numerous provisions of the Title 4D program or the rights that might have been created, the latter court held that respondents had an enforceable individual right to have state achieve substantial compliance with Title 4D. It also disagreed with the district court's conclusion that Congress had foreclosed private 4D enforcement actions by authorizing the Secretary of Health and Human Services to audit and cut off funds to states. You see this? With states that do not comply with what Title 4D does. Held, and this is what's important. Remember we talked about it earlier in the other case. Held, Title 4D does not give individuals a federal right to force a state agency to substantially comply with Title 4D. You see that? It has nothing to do with whether or not child support is constitutional. It said they don't have a right to make the state agency comply with it under a 1983 action. How in the blue crap we got to the point where we thought that meant it was unconstitutional is beyond me. Because as you're about to learn, a plaintiff seeking a 1983 redress must assert the violation of a federal right, not just a federal law. And the cool thing about federal courts is when they busting your head open, they always give you the damn case law. This is why we're telling you to get out of here with that foolishness. Here's the case law. And three principal factors for determining whether a statutory provision creates a privately enforceable right is: one, whether the plaintiff is an intended beneficiary of the statute; two, whether the plaintiff asserted interests are not vague and amorphous to the point or to be beyond the competence of the judiciary to enforce, meaning it just can't be out there. You have to have something that has to stand on. And whether the statute imposes a binding obligation on the state. And they give you the case law one more time. And by the way, even if a plaintiff demonstrates such a right, however, there is only a rebuttable presumption that it's enforceable under 1983. Dismissal is proper if Congress specifically foreclosed a 1983 remedy, meaning when the law was written, they may not have provided that you can use 1983 to address what you perceive as a violation of that particular law. And so when you go to read whatever you're going to sue somebody under, you want to make sure that you have an enforceable right to sue them. And again, that's none of this I'm telling you is legal advice. We're all just reading this together and should be coming up with an idea as to why nothing in here says child support is unconstitutional. In fact, if you wanted to find out, just do Control F and see if the court said child support is unconstitutional. You see the other words together, but if you wanted to see where it says the court deemed it unconstitutional, there you go. In fact, what's crazy is I don't even know if unconstitutional is even in this thing. Now that I'm looking at this case, let's see if it unconstitutional doesn't even appear in this case. There you go. The word unconstitutional doesn't even appear in the case. So I need somebody, anybody, to show me where and how we came up with the assumption that Blessing versus Freeston determined that child support was unconstitutional. It just says that the mothers don't have an ability to enforce a private right for non-compliance under 1983. I don't think we need to go any further. I think this has been, at that point, my question to the many who think that child support is unconstitutional is say, where did you get it out of this case or the other case? Let me see if we can find the word fraud in here. Fraud is fraud. Okay, no fraud appears in here also. Probably did the other case. There's a prohibiting. I don't know about no. Let's see what prohibiting comes up. Grant permanent and necessary appropriate interlocutory injunctions prohibiting continued adherence to aforesaid pattern and practices requiring affirmative measures sufficient to achieve as well as sustain substantial compliance with federal law. That sounds like they might have done. Here they go. Oh, okay. The respondents claim the state's systemic failures violated their federal rights under Title 4D, invoking 1983. They asked the district court to grant them the following relief: enter a declaratory judgment, do all this, and what they're doing is giving you background on the case when you start to do this kind of stuff here. And what I would suggest to people to do at this point is to go find out why they didn't get it. But Justice Scalia did say that the mothers are strangers. I believe it was. Is the word strangers? Yeah, I think they were strangers to to a contract. And this is Scalia with whom they concurred. And despite the fact that I didn't think a lot of them blessed the dead, by the way, rest in peace, Scalia. When it came to some things constitutional, I thought he was actually on point with. I've read a lot of his. I have a couple of his books as well. Some things that absolutely didn't agree with him, because if I agree with him and what the so-called founding fathers' intent was in some instances, I wouldn't be up here reading this with you. I'd probably be somewhere baling hay. So I'll just leave it at that. Here he goes. I agree with the court that under the test set forth in Wright versus Roanoke, 1983 does not permit individual beneficiaries of Title 4D of the Social Security Act to bring suit challenging a state's failure to achieve substantial compliance with requirements of Title 4D. See that, people? That conclusion makes it unnecessary to reach the question of whether it authorizes the beneficiaries of a federal state funding and spending agreement to bring suit. It's right there, people. And by the way, we look for the word stranger, right? Where do we find stranger? The state promises to provide certain services to private individuals, in exchange for which the federal government promises to give the state funds. In contract law, when such an arrangement is made, A promises to pay B money. In exchange, B promises to provide services to C. The person who receives, here you go, the person who receives the benefit of the exchange of promises between the two others is called a third-party beneficiary. Until relatively recent times, the third-party beneficiary was generally regarded as a stranger to the contract and could not sue upon it. That is to say, if an example given above, they broke his promises, it don't make no goddamn difference. But here you go. Go back and read it. It's clear, people. And as we did right here, just get the Control F and let somebody find out where you can find anywhere child support's been rendered unconstitutional. I think that, and I'm hoping, I'm pretty sure I'll get some pushback, and that's fine. I believe in spirited debate with everything that we do. So again, if you all can find it somewhere where child support was deemed unconstitutional, somebody please bring it to me, illegal or unlawful. And do your own Control Fs, by the way. So that's something free. And with that being said, hey, listen. Well, I'm going to tackle a couple other things. I got to do a follow up to the last. Actually, I have a hearing, I believe, on Wednesday. Actually, I don't believe I have a hearing on Wednesday to address the video of how to handle an officer, whatever one is, with Arabella Campbell. Miss Campbell, despite what we all heard in the video of $836, that we discussed $56,000, and everybody with ears knows that we didn't do that. More importantly, everybody with ears also knows that the mother had filed an affidavit. So I'm gonna get ready to start getting ready for that hearing on Wednesday. Anybody who wants to watch it, I'm gonna make it available on Zoom. I haven't figured out how to make this software incorporate the Zoom to everybody, but if you want to, I will put the information on my YouTube, and you can just hit the Zoom link, and you'll be able to see me in an actual courtroom proceeding, address child support. And by the way, I do have these reverse child support shirts available. So if you want one, hit me up, and I'll get one drop shipped to you. I'll end up putting it inside my store. I think I had them in the store for a while, but that was when I was getting ready to retire, which I'm still getting ready to retire from this, because at 56 years of age and having children in college, and being the proud father of a daughter who's about to be a doctor, I have better things to do with my time, like making sure I'm not the most academically credentialed individual in the family. I'm thankful to the mothers who we at some point found a way to meet and make resolution and move forward in the best interest of the children. I do expect to have 3 doctors. So again, Pops needs to get on his business and at least get this master's things finished, but or maybe even law school. But I will never practice. I'm too old for that right now. So with that being said, sometimes it's not about right or wrong. More importantly, it's about clarity. And you will never reach a resolution if you're not willing to engage in honest dialogue, even if that dialogue is with yourself. Take time to hug the person you love and love the person you hug. Trust me, we're not guaranteed tomorrow. And I would love nothing more than to give a hug to the people that mean the most to me and have meant the most to me. So that being said, on behalf of GD Non-Attorney Pro Se Consultants, you can check me out every Monday on Chop Shop. I'm Greg Doss. I'm the also infamous DJ Squid. I'm saying peace. I'm saying chicken grease. Hey, if you all want me to address any other cases or read any other cases, just let me know. You can see my information on in the bio for this, for all my videos actually. Hey, and let's address some stuff and try each other help one another. Hey, I'm saying peace. I'm saying chicken grease. I'm Greg, and I'm out.